Hello and welcome. My name is Ronald Onyango. I'm a Solicitor and Migration Consultant. And in the video, I will be sharing 5 ways you can legally stay in the UK if you are an overstayer. If you're living in the UK without a valid visa, you may be feeling anxious about your future. But don't worry. There are legal options available for you to apply for permission to stay. Each case is obviously different, so it's important to understand which route applies to your own situation and circumstances. Let's get started. The first one is as a parent of a British or settled child. One of the most common ways to regularize your stay in the UK is through the parent application. If you have a child who is a British citizen or has settled status or lived in the UK for at least 7 years, you may be eligible to apply for legal residency based on your parental relationship. What does this mean? The UK government prioritizes the best interest of children. If your child is British or settled in the UK, the government will consider whether it would be reasonable to expect the child to leave the country with you. In most cases, forcing a British settled child to relocate is not seen as reasonable. What you need to prove is that you have parental responsibility and are actively involved in your child's life. Also, that you have an existing relationship and provide care for the child, including financial and emotional support. If you meet these conditions, you can apply for leave to remain based on your relationship with your child. The next one is a partner of a qualifying child's parent. If you are not the biological parent of the child, but you are in a relationship with their mother or father, you may still be able to apply under the partner application. The eligibility criteria is that you must have been in a genuine and a subsisting relationship with the child's parent for at least 2 years. The other child's parent must be British or settled in the UK. You must show that your removal from the United Kingdom would negatively impact the child's well-being and stability. This application is particularly useful for step-parents or partners who play an active role in raising the child. The key focus is on maintaining the family unity and ensuring that the child's welfare is not disrupted. The third one is as a private life application on the 20-year rule. Another legal way to remain in the UK is through the private life route, specifically the 20-year rule. This rule allows people who have lived in the UK continuously for 20 years to apply for legal status. The key requirements include that you must prove that you have been in the United Kingdom continuously for at least 20 years. You must provide strong evidence such as bank statements, school or medical records, tenancy agreements, letters from employers, landlords, or community members. Even if you've lived in the UK without status, as long as you can prove continuous residence for 20 years, you may qualify to apply. However, the Home Office is very strict when assessing these applications. Hence, any gaps in your residency history can weaken your case. The fourth route is as a private life application based on the 7-year rule for children. If you're an overstayer with a child who has lived in the UK for at least 7 years, you may be able to apply under the 7-year rule. Why is this important? The UK government recognises that children who have spent a significant part of their lives in the UK develop strong social, educational and cultural ties. Hence, forcing them to leave could have a negative impact on their well-being. Eligibility: that the child must have lived in the UK for at least 7 years continuously. You must also show that removing them from the United Kingdom would not be reasonable. Even if the child does not have British citizenship or settled status, their long residence in the United Kingdom can be a strong argument for your application. This route is especially useful for families who have been in the UK for many years but do not have legal status. The fifth route is where there are significant obstacles to integration in your home country. If you haven't lived in the UK for 20 years but still face serious difficulties returning to your home country, you may qualify under the significant obstacles to integration rule. The Home Office defines significant obstacles as being unable to speak the language of your home country, or facing discrimination, violence or persecution in your home country, or having no family or social connections in your home country of origin, or even experiencing serious health conditions that cannot be treated in your home country. If you can prove that returning to your home country would cause extreme hardship, you may be granted leave to remain in the UK. However, this is a high threshold application, so you must provide strong evidence to support your claim. In conclusion, these are the 5 ways to legally remain in the UK if you are an overstayer. If any of these apply to you, consult an immigration expert to get personalized advice. As a solicitor and a migration consultant, I can help guide you through the process. If you need professional assistance, feel free to book a consultation with me. For more expert insights, subscribe to the channel, turn on your notification, and stay updated on UK immigration laws. See you in the next video when I discuss the next 5 ways to remain as an overstayer. Thank you.